big legal win, but against some of the union bosses, some of the damages they do. Folks, joining us right now, he is the president, National Right to Work Foundation. It is our friend, Mark Mix. And Mark, this is significant because of the liability that comes into play, my understanding, with a lot of these union bosses when damage has been done to property.
Yeah, indeed it is, John. It is an important decision. And fortunately, it basically blocked the granting of another privilege for big labor union officials when they use violence and property destruction to get their way. The Supreme Court, in an 8-1 ruling, ruled that they ruled that the Washington State Supreme Court was wrong when they decided that the employer in this case, Glacier Northwest, which is a concrete company, didn't have a cause of action under tort law for intentional property damage that was inflicted by the Teamster Union on that company. And just to give you a real quick thumbnail of what happened was workers showed up at the yard in the morning. They loaded their cement trucks up for a big pour in Seattle, and they brought the trucks back to the yard in a labor dispute and left them on the property yard with the cement, with the drums still spinning. But obviously, cement is destroyed after some period of time, and the company lost about $100,000 in property in what was, these workers going out on strike. And so the business went to the trial court and the County Superior Court and asked for a tort claim, saying they owed us money for property destruction. And the trial court said, no, we don't have jurisdiction. This is the National Labor Relations Board that would have jurisdiction over this. They appealed that. They lost at the appellate level. And then they went to the Washington State Supreme Court, and they lost there. And so they applied to the U.S. Supreme Court for a petition to hear the case. The court here in Washington decided to hear the case, and they ruled 8-1 that they ought to look at this again, because the idea of intentional property damage is something that should have the ability to someone to act. And if unions would have won this case, then basically, John, they would get to destroy property at will and leave it up to the politics of the National Labor Relations Board as whether or not they were going to be penalized for this. So in essence, it was a big win for denying union officials an additional privilege that they already have many under the law.
And Mark, if you could just touch on, because this is something we've seen around here sometimes with the strikes and the amount of damage that is done left behind on the property, they act as though there's no accountability on their end.
Yeah, that's right. And that's really the claim that the Teamsters making. And Ketanji Brown, the only one justice that came out and said, no, everything was honky-dory and everything was fine, basically is saying that the union officials can do anything they want, and it's protected activity under the National Labor Relations Act, and it's leverage to achieve a legitimate union objective. And, John, we've seen this before by the Supreme Court back in 1973 when they ruled in a case called Edmonds that union officials could not be prosecuted for, quote, acts of violence, unquote, that are used to achieve legitimate union objectives. So in this case, while there wasn't violence against an individual, there was significant and material property damage. And if the Supreme Court in Washington State would have been allowed to uphold their decision, then basically union officials would have a new license to do property damage and say, well, you got to go to the National Labor Relations Board to get that decision. And, John, I can tell you, at least for the next year and a half, that National Labor Relations Board that was nominated and confirmed by Joe Biden and the Democrat Senate, they're not interested in giving, business people any more opportunities to go back after union officials that use this type of activities to get their way.
Now, Mark, folks, again, we're with Mark Mix. Mark, if you would just touch on, and Mark is, of course, president of National Right to Work. You recently penned an op-ed for Fox News. If you wouldn't mind indulging us and touching on that a little bit.
Which one was that, John? Was that on this case, the Glacier case?
The depth of the union boss legal privileges, yes.
Yeah, and that's what we really focused on in our brief to the Supreme Court after they decided to take it. And we checked off all the privileges they have, and that is, first of all, the one I just mentioned, the Edmonds decision, the inability to prosecute them under federal extortion and racketeering laws when they're trying to achieve legitimate union objectives. Secondly, we go back 90-plus years, and we look at the National Labor Relations Act, which gives union officials officials the power and the privilege to have a worker fired if they don't support financially the labor union. Meaning you have to pay union dues or fees in order to keep your job. And really the original injustice in all of that, John, is that the union can force you to associate with them, even though you voted no, didn't want them, didn't ask for them, but yet you're in this collective. You're forced into this collective by federal law. So these types of privileges, and then the antitrust laws, they're exempt from antitrust laws, and just so many of these privileges they've been granted under the law that it's getting to be outrageous. No other organization in the country, no other institution in the country has the type of privileges that organized labor and particularly union officials have when it comes to forcing workers into collectives, and then, in this case, using property damage and or violence to get their way.
Folks, again, he is National Right to Work Foundation President Mark Mix. Mark, excellent job as always. Great to talk to you, and we'll talk to you again.
Appreciate it, John. Thank you.